The California Chief Justice has commented on the bee fish. Just when we thought the bee fish could not get any more crazy. What are bee fish? I'm so glad you asked. I am so glad you asked. What are bee fish? Well, I don't blame you for asking if you haven't been here for a little while. But California wanted to protect bees under its environmental regulations. California wanted to protect bees under its environmental regulations. Unfortunately, the environmental regulations in question did not specify bees as a protected class, but it specified fish as a protected category. And thus, the decision from the courts is that bees are a type of fish. Okay, so this California Supreme Court has denied review on the case. The Chief Justice says our denial of petition review does not communicate any particular view regarding the merits. So they want you to make clear that they do not have an opinion on the fish bees. Thus, all should understand our decision to deny review of this case is not an endorsement, nor is it a rejection of the statutory analysis undertaken by the Court of Appeals, which determined that bumblebees, a non-aquatic invertebrate, are susceptible to being listed as endangered under the California Endangered Species Act, also known as the Fish and Game Code, because the statute applies to fish. Again, let's just read that. I'm going to pull the mic right up close to my face for the full proximity effect. Okay. We're going to do this full proximity effect style. And I want you to really understand what the Chief Justice just wrote. Okay. I want you to understand the words that are coming out of the Chief Justice's mouth right now. Okay. All right. We are not endorsing, nor is it a rejection of the statutory analysis undertaken by the Court of Appeals, which determined that bumblebees, a non-aquatic invertebrate, are susceptible to being listed as endangered under the California Endangered Species Act because that statute applies to fish, and that invertebrates are included within what the Court of Appeals determined to be the applicable definition of fish. Thus, the emoji that is now available to those who are members of this channel. The bee fish. There is a reason that there is the emoji available to members of this channel of the bee fish. Could I please, for all the people who have the scales by their name, would you be so kind as to go into your emojis and please select the bee fish. Let the bee fish roll. I want to see those bee fish, baby. Bee fish. Bee fish. Yet, if experience is any guide, our decision not to order review will be misconstrued by some as an affirmative determination by this court that under the law, bumblebees are fish. A better informed observer might observe, how can this court pass up this opportunity to review the Court of Appeals interpretation under the Fish and Game Code, which seems so contrary to common knowledge that bumblebees are not a type of fish? Doesn't this clear disconnect necessarily amount to an important question of law, warranting this court's intervention because the legislature could not possibly have intended this result? Were things always so simple? Oh my God. Are they about to say some more stupid? Hold me. Please. Please. I can't. Please don't make it more stupid, please. Were it so simple? Careful analysis of the statute to divine legislative intent can sometimes yield results that might seem surprising at first blush. Courts engaged in this task have interpreted less as more and unlawful as lawful. Apparently, also, the United States Supreme Court at some point has concluded that seas requires no water at all, and that fish is not a tangible object. Which, that part actually kind of makes sense, because fish aren't really an object as such. But okay. These kinds of seemingly illogical outcomes can in fact be captured by enacting legislative intent in a variety of circumstances. A statute may be construed in a manner that goes beyond literal meaning of text to avoid absurd result a legislature could not possibly have contemplated. Sometimes courts perceive a scrivener's error or typo that must be corrected to vindicate the intent behind a measure, or the context surrounding the use of a word or phrase within a statute convey that it carries an unusual meaning peculiar to the law. The Court of Appeals conclude the interpretive question below it fell into the last of these categories, with the consequence that bumblebees, I can do this, I can get through this, with the consequence that bumblebees should indeed be regarded as fish. Moreover, a decision not to order a review does not prevent us from considering the reach in some future case, at which time we may agree or disagree with the analysis. In the meantime, the legislature is in a position to make sure whatever statutory amendments it may regard as necessary or useful. For although it may not be exceptional for our court to determine a particular word or phrase within a statute carries a meaning that deviates from common parlance or understanding, such decisions can also provide notice to legislatures that some clarification may be in order. It's all about the bee fish, baby. It's all about the bee fish.